the Nigerian government had agreed to supply gas to a processing plant in Calabar founded by P&ID, but the now botched contract, which never kicked off, was for the processing of wet gas into lean gas by P&ID for Nigeria within an expected period of 20 years. Live in the studio joining me is Babajimi Ayorinde, founding partner at the New Practice, where he heads the Commercial Dispute Resolution Practice Group. Thank you for joining me in the studio. All right, this particular situation has been making the rounds on the news, but then we've also seen a number of misinformation and misleading information regarding it. Can they help us understand the situation better?
Okay, so I think one of the things that has been thrown out a lot in the media is that Nigeria was fined. That is not correct. When you use the word fine, that connotes that it's a penalty or a punishment for some offense that Nigeria has committed. What was awarded against Nigeria was damages, and it was damages because the tribunal found that Nigeria did not keep to its obligations or did not comply with its obligations under the contract. In law, damages are awarded to compensate the innocent party, essentially to restore that party to the position they would have been in if there wasn't a breach. So it's not a fine, it's damages, and it's basically Nigeria being asked to pay reparations to P&ID for us not...
for damages?
Yes.
Primarily?
Damages primarily because the tribunal found that we did not comply with our obligations under the contract.
Now, we know that for the arbitrators, they particularly work based on whatever evidence that has been put before them. P&ID came forward and said, oh, they had already spent $40 million in preparation for this particular contract. But then, can you challenge an arbitration award?
So the simple answer is yes, you can challenge an arbitration award. But you can only challenge an arbitration award in very, very narrow circumstances.
Okay.
Now, one of the concepts that underpins the system of administration is what you call party autonomy.
Okay.
And what that essentially means is that parties have the freedom to choose who their arbitrators would be,
okay,
the procedure to be followed for their arbitration, and the law to govern their arbitration. The other side of the coin is that once you've chosen those arbitrators and you've basically submitted your disputes to them, you're bound by the decision they deliver, for better or for worse. The law will only allow you to challenge the award in very limited circumstances, for example, where you claim that the arbitrators have in some way misconducted themselves, if you allege that the arbitration award was fraudulently procured, or if the arbitrators have exceeded the authority that was submitted to them by the parties. So it's not that easy to set aside an arbitration award. You need to have very, very good reasons.
All right, and finally, before we go, in a case where Nigeria is able to prove that there was some form of fraudulent activity while the contract was being negotiated for, what effect would it have on the court ruling?
Okay, so I can't give you a specific prediction on this particular case, but what I would say is that the courts in Nigeria and also the courts in the UK will never lend themselves to a scheme that is fraudulent. They won't allow themselves to be used to perpetrate fraud. And that's a principle that has been established in both countries for decades. I know for a fact that the UK Arbitration Act does allow you to ask the court to set aside an arbitration award if you believe that that arbitration award was procured through fraudulent means. However, there is a caveat. The UK Arbitration Act prescribes a period within which you're supposed to make that application to the court.
28 days
It's 28 days. Now, it doesn't mean that you can't make the application after the 28 days, but you need to come up with very good reasons. You either need to assert that you did not know of the fraud, because it's possible for you to have found out much later, or you assert that you you had taken reasonable steps, you had done your due diligence, and despite that, you didn't uncover the fraud.
Anything.
Yes. So unless you can once again fit yourself within those narrow limits, it's going to be very difficult for you to get a court to set aside an award based on fraud.
All right, thank you so much. We would have had a lot to talk about, but we're out of time now. But thanks for joining me in the studio.
Thank you.
And that's all on Business News.